Hey everyone, welcome back to the channel. And trust me, this is one you'll want to watch all the way through. Today, we're diving deep into the case of a sovereign citizen I've been tracking for months out of Thurston County. And things are finally starting to escalate. With a jury trial right around the corner, now's the perfect time to break it all down. Every hearing, every argument, and every moment of courtroom chaos, pulled together into one complete, start-to-finish timeline. By the time his next court date rolls around, you'll know exactly how he got here and why this trial could turn into something you won't want to miss. Let's get into it.
Your Honor, this is Mr. Valentine, whose matters, I believe, are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe my office had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed, and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
That might be one of the worst justifications I've ever heard for representing yourself in a criminal trial, especially when your freedom is literally on the line. Think about it this way. You're in Los Angeles, and someone tells you you've got 24 hours to get to New York, or everything falls apart. Are you really going to turn down a trained pilot? Someone whose entire profession is safely getting people from point A to point B, just so you can climb into the cockpit and try flying the plane yourself? Sure, there are everyday things you should handle on your own. Tie your shoes, get dressed, maybe remember your helmet. But there are also moments when you hand the controls to a professional. Flying a plane, performing brain surgery, and absolutely navigating a courtroom where one mistake could cost you your freedom. He thinks going solo is some kind of power move, but in reality, it's less confidence and more turbulence, and it's setting him up for a crash landing he may not walk away from.
All right, well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up, because I was confused about the dates. The clerk told me the wrong date. I showed up, I gave the clerk a letter, I wrote a letter to the court, and I also wrote counterclaims and responses to the state attorney general's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi-Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce it. If not, I do not wish to contract with any members of this court.
First of all, yes, you absolutely entered into a legal obligation the moment you chose to drive drunk on public roads. That's not hidden sovereignty doctrine or some mystical loophole. It's just basic, everyday law. When you use public infrastructure, you agree to follow public rules. It's that simple. And that whole performance about the court being in Prius, while you're supposedly implementing Rule N, that wasn't legal insight. It was word salad dressed up to sound impressive. Here's the reality. The court is in Prius because it's a court of original jurisdiction, the trial court. It's the place where facts are decided and authority begins, before anything ever reaches an appellate court. So when you proudly announce that the court is operating in Prius, you're not exposing some secret flaw in the system. You're literally confirming, out loud, that this is the very court that has power over your case. You didn't outsmart the process. You just validated it. And Rule N? It's not a magic spell you get to invoke because you feel like it. It's simply a procedural mechanism that only the court can apply under specific circumstances. It requires a judge. And since you are very clearly not the judge, you won't be implementing anything today, tomorrow, or any day that ends in Y. Watching him try is like watching someone insist they can control the weather by blinking harder. Confident, dramatic, and completely disconnected from reality.
Mr. Valentine, I'm going to hold you on $15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So $15,000 cash or bond has to be posted on each one of these separately. And then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns. And don't drive unless you have a good license and proof of insurance. I'm going to set another court date. You would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Well, what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do.
I am not pro se. I'm sui juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that?
No, it's just free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona, that I live in the likeness of another?
So now he's claiming he's not actually himself, but a persona, some separate entity merely living in the likeness of a person. Let's slow that down and make it painfully simple. You'd better hope the judge sees you as a person, because the alternative does not work in your favor. Objects don't have constitutional rights. Chairs don't get due process. Filing cabinets don't demand jury trials. The law protects people, period. The moment you start arguing yourself out of personhood, you're not unlocking some legal cheat code. You're stripping away the very protections you desperately need. You're sawing off the branch you're standing on and acting like it's a strategy. It's not clever, it's not profound, and it's definitely not persuasive. It's self-sabotage dressed up as philosophy, and the only person buying into it is him.
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to the
you
facts, man.
you can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
One attorney.
So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do postpone, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the Scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post stamps.
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm a sound mind.
I'm not denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel. We can talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. All right, so we're done today, and those orders will be given to you in the jail.
All right, I don't consent to any of those orders.
You don't get to consent to a court order any more than you get to consent to sitting in jail. Your approval isn't part of the equation, because that's not how the legal system works. Court orders aren't suggestions, and incarceration isn't a choose-your-own adventure. When a judge issues a ruling, it applies whether you agree with it, understand it, or like it. That's the reality of it. But then we get to his next hearing, and trust me, this is where things take an even stranger turn. This time, his entire family packs into the courtroom, and the energy shifts almost instantly. What unfolds next says everything about how far this sovereign citizen mindset has spread, and just how hard the judge has to work to keep the room tethered to reality.
And folks, I'm guessing you're all here for the same case, since you're all sitting shoulder to shoulder. What case are you here for? Okay. And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah, hold on. I'll let you know when I need to hear from you.
okay.
So, Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation.
Okay.
I have advised.
Okay,
He wants
I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with two cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
Are you attempting to intimidate me under the color of law?
If this judge really wanted to intimidate him, she wouldn't need a gavel. She could just slide a basic math worksheet across the table and watch him spiral for the rest of the afternoon. But intimidation isn't the goal here, not even close. If anything, the judge is bending over backward to help him, because it's painfully clear he has no idea how to help himself. Every choice he makes just digs the hole a little deeper. And meanwhile, the court keeps lowering a ladder right in front of him, and he stubbornly refuses to climb it.
No, we're not doing anything like that. We're here on a pretrial. You have a confirmation hearing set for the 18th of October. Mr. Valentine, you have anything to say about that status? Otherwise, we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you is why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing and have consideration of those. Thank you.
You're really putting the extra in special appearance today. And the best part, you just dropped a dramatic "We the people" like you're delivering the opening line of the Constitution itself. Bold choice, especially considering that phrase refers to an entire body of people, which is pretty ironic because you've spent this entire hearing insisting you're not even a person in the first place. You can't wrap yourself in "we the people" while simultaneously trying to opt out of the category of people. That's not how this works. You don't get to claim the protections of the Constitution while arguing you don't qualify for the very group it protects. Pick a lane, my friend, because right now you're trying to have it both ways, and the logic just isn't landing.
We need to get you unmuted.
Yes, ma'am.
All right, so there are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not?
No.
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay, I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue some motions that I submitted to the court. A motion to dismiss, a judicial notice that I've dismissed, about misconduct of the court and denied of access to the court, and I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony, to my house. I'm not sure what that was. The motion was never served to me, and the docket was never served to me either. It was mailed to my home. I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay. Well, this is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
It's
Mr.
the state's
Weston?
understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether the court should grant funds for Mr. Valentine to hire an investigator.
All right, that wraps up the hearing. Nothing especially complicated. Just another round of classic sovereign citizen logic delivered with absolute confidence and absolutely zero self-awareness. The arguments didn't clarify anything, didn't move the needle, and definitely didn't help his case. They just added another layer of chaos to the record. Honestly, the only real plot twist was him showing up with his entire family in tow. Like this was some kind of live stage performance titled How Not to Handle Your Court Case. And if they walked in expecting clarity or a breakthrough moment, they definitely walked out with the opposite. More confusion, more secondhand embarrassment, and a front row seat to exactly how not to navigate a courtroom.
That's not part of the motions I have here that were filed.
There was a motion filed. I can look it up real quick, Your Honor.
Since the last hearing is what I was looking at. So there was...
Yeah, I objected to his denial of those motions as well, because I already submitted an affidavit of prejudice and he disqualified himself. So he shouldn't have been making any judgments on the case after that point. He also said himself that today was going to be a special motion docket where my motions were going to be heard today.
So what I reviewed is what was filed after the 18th, and that was October 21st. I have a request to release you and your request, let me get back to your court to dismiss these charges, motion to release you, and that's what I reviewed. So is there something else pending that I was not aware of after the 18th?
On this October 18th, there's one that says in Laserfish motion to request discovery, parentheses 020, parentheses. In that one, that's based on the state's notes. It shows that that was the only motion that was going to be argued today.
All right, Mr. Valentine, it looks like I need to go back and kind of review real quick those issues. I thought they were all heard on the 18th. And either you can just sit right there while I read everything here, or which probably is the best thing to do. So let me just review all that you've filed here again. Then I'll turn right back to you. So just hang in there. So, just before I get to everything, Mr. Valentine, motion request, I guess you titled it to request all of the discovery in this case, but you say that it seems to me, maybe I'm misreading, one, that Michael Valentine had an attorney in the early stages of the hearings. Is that just a fact, or are you asking the court to appoint counsel?
I'm stating a fact that at the beginning of these proceedings, I was working with an attorney.
And then they never gave you the discovery. Okay. All right.
Yes.
All right. Get it.
That's the state's understanding as well, Your Honor.
All right. I've had some time here to re-review and review what's been filed in the court file from the 18th of October on forward. As to your motions from the 18th on forward, and the docket and your pleadings. So As to discovery, let me direct first to Mr. Weston on behalf of the state. Has all discovery been provided to Mr. Valentine?
Correct, Your Honor. So on October 18th, 2024, Judge Buckley ordered that the state provide Mr. Valentine discovery. 5 days later, DPA Thompson himself drove to the jail and delivered all discovery material to Mr. Valentine, which included the citation, police reports, an offer sheet from our office, thumb drives of dash cams, and then the request forms for those dash cams as well.
Okay, so a thumb drive that he could view those, a request form for the dash cams. What does that mean?
That when there's a dash cam involved, such as here, our office generally has to send out a request for that dash cam, and that form is just a request asking Washington State Patrol to disclose their dash cams to us.
Okay, but you provided a thumb drive that had those dash cams.
Correct, Your Honor. Thumb drive of the dash cams.
And all this information is what the state intends to use in trial against Mr. Valentine.
Correct, Your Honor. Based on the subpoenas that I looked at recently that were sent out for trial, the trooper that's testifying is one of the troopers that is testifying. His dash cam would be on this drive. The police report of that trooper would have been provided in this discovery packet as well. All the information that we would be using at trial was in this discovery packet that was provided to Mr. Valentine on December 23rd.
Was it provided before this at any point?
The state is unaware on whether it was or not. The state had the belief that defense counsel, who was previously representing Mr. Valentine up to a certain point, would disclose such materials to him when the court allowed Mr. Valentine to proceed pro se. But this state doesn't know why it wasn't provided to him from the prior defense counsel. But upon realizing that Mr. Valentine did not have the discovery packet, the state did provide such material at that time.
And on the witnesses that you're expecting to call to testify, the substance of their information is included in that discovery?
I would believe so, Your Honor. Based on the subpoena that was sent out, one of the witnesses are Trooper Benjamin Crabtree, one of a dragger technician, and because there was one of the charges is driving while license suspended, there is a DOL representative that it will be a witness in the trial as well.
It looks like a witness list was provided while Mr. Gasling was Mr. Valentine's attorney back in the beginning of the year, at least March, I believe it was. So then, Mr. Valentine, as to that discovery, you thinking you're missing something or you should have something else in discovery?
No, ma'am, I didn't receive the discovery in a timely manner. Counsel was ineffective in discovery footage or the reports with me. I asked on multiple occasions to obtain the video so that I could build a proper defense, and they told me on multiple occasions that it had to be approved by the prosecutor and redacted, which never happened. I waited and waited, never happened. And after counsel's ineffectiveness, this is where I made the choice to proceed to the jurors because I have my own best interest in mind, and it seems that the public defenders that were appointed to me were not assisting me effectively, and this was recreating a manifest injustice. So now I have received it a few days before we're supposed to be going to trial. I have reviewed the footage, and there is fraudulent and misleading statements made by the trooper that I have already submitted a motion to suppress that evidence that I'm sure the court will be getting shortly.
So we're a couple weeks before trial, or before confirmation. We've got trial scheduled the 18th, so we're 3 weeks out. All right.
Yeah, I would ask the court that either the prosecutor or counsel be sanctioned or some remedy be met for the violation of discovery.
In other words, the court wasn't buying any of it, and it was straight back to jail. No dramatic victory, no last-minute loophole, just the very predictable consequences of arguments that never had a legal leg to stand on. Now let's move ahead to the next hearing, technically the one after the next, since the middle session never made it to YouTube. But based on the docket, we didn't miss much. It looks like yet another judge spent the entire time methodically shutting down his motions one by one, blocking every attempt to cram more sovereign citizen word salad into the record. Same pattern, different day. Big confidence, zero legal foundation, and the judge stuck doing cleanup duty while he keeps swinging at arguments that were never going to land.